Good morning and welcome to the 28th meeting of the Rural Affairs and Islands Committee in 2025. Before we begin, could I please ask everyone to ensure that their electronic devices are switched to silent. Our first item on the agenda is consideration of the Crofting and Scottish Land Court Bill at Stage 1. This morning we will take evidence on the legal and procedural aspects of the bill. And welcome to the meeting Stephen Cranston from the Law Society of Scotland, Brian Inkster from Inkster Solicitors, Chris Kerr from the Registers of Scotland, Katie Mackay from FMS Law and Elliot Ross from Camus Consulting. Thank you very much for joining us this morning. We've got around 90 minutes allocated for questions and discussion this morning, and we do have quite a few questions to get through. So if I ask that the questions as well as the answers are concise, and don't feel you need to contribute to every question. If you don't have a different opinion or no particular position, don't feel you need to contribute. And finally, you don't need to operate your mics. We have a gentleman here that will do that for you. So I'll just kick off. What I'm doing is looking to seek your views on Section 1 of the bill, which revises the duty of crofters to allow a third distinct option for croftland, and that's environmental use, and specifically on the calls for some greater clarity around the definition of the use of the word environmental use. So who would like to kick off? Ellie.
Good morning, Convener Kitty. My view on the proposed change in the bill is I don't have a problem with it necessarily. I don't think it's necessary. So at the moment, you can there are largely speaking two ways that you can use your croft. You can either cultivate it, which essentially means agricultural use, or you can put it to some other purposeful use. And that other purposeful use has a really broad definition already in law, and that definition says that it means any planned or managed use which doesn't adversely affect the croft or surrounding land, or adjacent land, I think is the term. So that, I mean, I've been saying to clients for years who've been asking me for advice, can I use my croft for rewilding? Can I use it to establish, habitat management and that sort of thing? And my advice to them over the years has been, yes, you can, as long as you have a plan. So you can't just do nothing with your croft. So if it looks to the outsider as if you do nothing, you have to be able to prove to the Crofters Commission or indeed your landlord, if it's a tenanted croft, that this is thought through. So it might look as if it's a field full of rushes, but in fact, it's been carefully managed in line with a plan that you can actually produce. So I don't think it's necessary, although I suppose the change that is coming in now is that you won't need to seek your landlord's consent to put your croft to an environmental use. So at the moment, for agricultural use, you don't require landlord's consent specifically. You can still be regulated by your landlord or by the Commission if it's deemed that you're not using it. But conversely, if you're putting your croft to another purposeful use, you're supposed to seek the landlord's consent. And if your landlord will not consent, then you're permitted to go to the Commission. So that is I think that's the change that they've obviously wanted to implement. And so I suppose if that was important, then the legislation is necessary, but no issue with it particularly.
So it sounds like, from what you're saying, that actually using the additional definition, environmental use, could actually make the situation worse, where we had a number of respondents suggest that abandoned crofts could be described as being rewilded. So could it potentially make the use, environmental use, make it more easy for people to use that as an excuse not to actually be managing their crofts in the way that's...
Potentially.
So it could make the issue worse. Any other thoughts? Stephen.
Yeah, thanks, Convener. I think our position when we looked at this was the definition of environmental use doesn't actually say anywhere that the use must benefit the environment. It just says it must be a planned and managed use which doesn't adversely affect the use of adjacent land. It then gives some examples which would be of environmental benefit, but the term itself, as it's defined, doesn't say that. And in our written evidence, we've provided a few kind of examples of things that might be on the edge of that. Would renewable energy generation, for example, be something that would be an environmental use or not?
So in your submission, you also commented around the subsequent change to the list of use for crofts would not prejudice those who had made long-term commitments to particular use prior to the removal of that purpose. How will that be an issue in practice?
Our thought on that was if there's going to be things that you can do, a lot of these environmental projects are fairly long-term projects. What we wouldn't want is for somebody to commit to a 40 or 50-year project and then have that use removed from the things you were allowed to use your croft for. If a crofter's committed to that, they should effectively be grandfathered into any future change. Okay. I've got supplementary from Emma Harper on Ellie's point and then Alistair Allen.
Thanks, Convener. Good morning to you all. So just thinking about crofts that are abandoned or just left, and then they'll say, OK, that's for rewilding. But the whole purpose of crofting is about communities, is about getting people into rural areas and tackling depopulation and having community benefit. So wouldn't part of the environmental considerations be about supporting communities as well?
My own view is that this proposed section of the bill actually goes to the nub of the bigger problem with crofting legislation, which is that there is no rationale for it. Nobody really knows, probably since the 1950s, why we have this system. So if you look at the powers and duties in the current Act of the Crofters Commission, they've got to do everything. So they've got to be encouraging the use of croft land for agriculture. They've got to be encouraging the use of croft land for other purposeful uses. They've got to be encouraging population retention. And one system can't possibly do all of those things. And in fact, when I was listening back this week to the evidence that Sir Crispin Agnew gave to the committee back in 2016, he made the point, as he did in his article in 2015, the article is called A Clean Slate, if anybody's interested. So he's been saying for years, as has, there are Crispin and many others as well, there is no clarity around the purpose of the crofting legislation. So on top of agriculture, which is traditional crofting use, and when people say crofting, that's generally speaking, unless you're a bit of a nerd about it, that's generally speaking what people are thinking of about crofting. But then you've also got diversified uses. And in my experience, the vast majority of people moving into the crofting system at the moment are putting their crofts to diversified uses, not traditional agricultural crofting. And now you've got this other proposed use coming in. So I think if there was going to be another bill in the future, and there is now widespread appetite for that, both in the crofting community itself and also the legal community associated with crofting, then that is one thing that I would welcome, some kind of properly thought through policy rationale for the crofting system that the legislation could then work around.
Thank you. Alistair Allen.
Thanks. On picking up on that point, I think there is widespread, my impression, is widespread welcome for environmental use being highlighted in this bill. I suppose, to pick up on what Emma's referred to the other about population retention, some of this comes down to how not just an individual crofter manages or justifies the decision, but how a community does. I mean, you can think of sort of hypothetical examples where every crofter in a village decided that they wanted to plant trees or something, and that you would then have, at least hypothetically, nobody left in the village who was actually actively, in the traditional sense of the word, using their land and taking part in the common life of the common grazings and so on. So, not that I'm suggesting that's going to be an outcome of this bill, but how do you foresee this definition of environmental use being managed in a way that prevents these kind of scenarios at a community level, at a common grazings level, as well as just asking individual crofters to justify their decisions.
Anybody like to take that question on? Katie.
I have a huge issue with this introduction of the environmental aspects. I think it would be unlikely that you would have a realistic township where there is absolutely nobody that has livestock, cattle, sheep. These people exist, but there are also people in the community, and it goes to what your colleague over there said. Crofting is about communities, and there are people in the community that maybe have full-time jobs. It's just not practical for them to have livestock, cattle, and they can certainly undertake environmental benefits to their croft, whether it be tree planting, whether it be some form of renewable energy, or if they've got the benefit of a river or stream running, that they can put you know, the river generating equipment in, electrical equipment in. So it's definitely going to open up possibilities within townships, but it's not going to annihilate a township, because there are people that absolutely love their animals, and what I find in practice is one croft's not enough for these folk with the livestock. They want to take over all the crofts, and that's something that we really need to be kind of discouraging, and making sure that it's open to all and open to new entrants as well, not just everybody that wants to take over all the crofts that already exist.
It was just a provocative question. I'm not really holding out this scenario, but it got the conversation going. And I suppose one of the questions connected to that, though, as well, you mentioned grazing, is of course there is a crossover here in many communities between the continuance of a grazed landscape and the continuance of many of the habitats which people are keen to protect. And crofting does hold out at least the prospect of low-intensity agriculture that might have a kind of benefit for the environment as well. So I suppose my question is really just about what you foresee this change in definition as meaning, and would it promote that relationship in future? The benefits of low intensity agriculture.
This is maybe a kind of slightly side issue related to this, but in the call for evidence, in my written evidence, I spoke about lack of enforcement of these provisions. So at the moment, with misuse, there's very little enforcement actually carried out by the Crofton Commission. So we could sit here all day speaking about whether we're going to introduce environmental use or not. But if there's not going to be any enforcement of these conditions, what does it matter? The Crofton Commission at the moment seem to concentrate on residency as an issue, because it's an easy task. They can look up a list of addresses and they can see that someone's not resident, and so they can send them letters. But the whole question of misuse is something that's never really been tackled in my memory. And I suppose, you know, to tackle misuse, you're going to have inspections of the crofts and so on. And it's a harder thing to maybe tackle. But I think that's something the committee needs to think about, because if we've got these, what you can or cannot do on a croft, but no one's actually policing it in any shape, form or fashion, does it really matter?
I think this is appropriate. I'm sort of going to jump members. I'm going to move to Evelyn Tweed, because Evelyn's got some questions that are specifically about the topic you just raised. I'll come back to you, Ariane. Evelyn, would you like to?
Yeah, thanks, Convener. Yeah, Brian, it's to follow on from what you were saying there. Do you feel that sections 3 to 7 of the bill give the Crofting Commission enough powers to enforce duties while protecting the rights of crofters and landlords?
So section
3 to 7.
Sorry, 37.
3 to 7.
Oh, 3 to 7. Sorry. 3 to 7.
So we're effectively looking at the enforcement of crofting duties. So follow on from your comments about it's all very well having different uses, environmental use. There's little point in having those if they're not enforced. So it's about the section that looks at that.
Okay, so I'm struggling to find this section. Yes, is it section 3, subsection 2?
2, 7.
3, 2, 7. 3, 4, 5, 6, 7.
Yeah, Katie, do you want to come in?
Section 3, if you don't mind. So the previous Crofting Act brought in the reporting duty for common grazings, but although actually it was there previously, but not written in the Act. And that is now being repealed with this proposed Act. But instead of having the Grazings Committee reporting to the Commission, this Act is now seeking that other people within the township or anyone in the township can effectively report crofts that are not being used. And I don't think that's conducive to building communities or, good relations in a tiny, small crofting township. The reporting by the Common Grazings Committees has actually fractured many townships already. So I completely object to the fact that you're now kind of encouraging other people living in a tiny village to report an empty croft or a croft that's not being used. It's just going to lead to problems, quite honestly. It should not be encouraged in any way, shape or form.
I guess, and I'm sure I'm going to preempt what Alistair was about to say, there was one of the issues previously was that the person complaining had to be recorded, and that might have been grazing committees, whatever, had to, and that caused issues. So this allows anyone to raise concerns.
Yeah, it does, but at the end of the day you have to ask the question as to why they're raising the concern, and generally people are raising the concern because they want the croft for themselves, and it's nothing but like a land grab by the back door, because effectively they're grassing somebody up so that they can try and get in there themselves.
You could say that, but guess if someone's not actually abiding by crofter duties,
well,
whether they're being grassed up or not, it's...
Sorry, you're getting to a much, much deeper level then, because ultimately you've got to consider financial viability of operating a croft. Having livestock, having cattle, that would need to be a full-time occupation, and you need economies of scale, so you need really multiple crofts to be able to do that. Now, that is at play in the background, and the people that are now operating a lot of these townships, they've taken control of several crofts, and they've got cattle in several crofts, but they're committing to that as a full-time occupation. But if you have a part-time job or a full-time job doing something else, and you live, excuse me, in the Highlands of Scotland, and you really only get good weather maybe 4 months of the year, it's virtually impossible to make any kind of living, and it ultimately becomes a very expensive kind of hobby. So, it's a bigger picture at play here than just reporting your neighbour because they're not using their croft. People are doing their best.
Alistair, did you?
Most people are doing their best, and I think that the problems you describe are very real. However, on our visit and in other contexts, we've also been asked as a committee, I suppose the question that Brian Inkster was alluding to there is what can be done to ensure that a village does not end up with multiple abandoned crofts in it by people who may well not even live in the country. So your question is about you don't want, for understandable reasons, and I completely appreciate them living in a community like that myself, you don't want people to be put in a difficult, poisonous situation.
That's fine, but that goes back to the point that Brian made is like, the Commissioner dealing with absentees, the odd absentee, but the Commission are the regulatory body here, and that was put in statute in 2010. So, it's up to them to be dealing with that. And, you can write all the legislation you like about new rules and what the Commission's going to do next, but quite frankly, they're not doing anything other than processing applications very, very, very slowly.
Brian?
I was a little bit confused, sorry, earlier, because with the numbering, but Stephen assisted me. So I now know that it was looking at a range of sections on enforcement. I was thinking it was one section. But anyway, I think those sections really look at someone informing the Commission and the Commission then taking some sort of action. And it says the Commission must, unless they consider a good reason not to, give her a notice. So how's this going to work in practice? Because if the Commission get a letter in from somebody that's complaining, and somebody complaining maybe be complaining because they don't like their neighbour, not because their neighbour is actually not properly cultivating or using the croft, what process is then gone through in the Commission? Again, I said earlier that unless you're actually going and inspecting the crofts, how do you know whether something is happening or not? So how does the Commission, on receiving a letter, how are they able to take what's said in that letter for granted and as being true. There would need to be some process whereby the Commission, and the only process that I can see is an actual inspection, but do the Commission have the resources every time they get a complaint about somebody not cultivating their croft to send out somebody to inspect? Probably not, you know. And I think that's a whole bigger question. And maybe something that can't be easily tackled in the bill. That's something to do with the resources for the Commission and so on. But that would be my view.
Ellie?
There is an appetite for increased regulation. There's no question about that. There's an acceptance these days that people not using their crofts or absentees who are not grasping the nettle and passing their croft on as perhaps they should, that's now becoming sort of socially unacceptable within these communities, which personally I believe is a good thing, and that is, you know, that's now quite widespread. And there's this desire for greater regulation. However, in my opinion and in my experience, the answer to that is not to encourage members of a community to clipe on each other. That comes with serious long-term consequences, and I heard Gary Campbell talk in his evidence session about generational disputes, I think was the term that he used. And we are all aware of many generational disputes, I'm sure you are as well. And that's how these things start. So somebody makes a complaint about somebody else, and in 60 years' time, their grandchildren are still talking about the fact that that happened. And it is incredibly harmful to what are already quite fragile communities in some cases. So the answer, in my own opinion, is not to involve communities and crofters in that process. If there is to be greater regulation, it must be better thought through. I don't necessarily, you know, I wouldn't necessarily go so far as to say, you know, don't, you know, to call for this to be removed from the legislation. I suppose because I'm already thinking about the next bill, and you know, that's the one that most of us are really focused on, to be quite honest, is the biggest thing about this bill is what it doesn't do, and it doesn't address really any of the problems that currently exist in the crofting system. And so most of us are now thinking about, well, what would that bill look like? The more interesting bill. But we can't forget that, you know, this is a job of work. The bill team have worked long and hard on it, and most of it is fine, actually. So, yeah, the concept of neighbours cliping on each other is problematic.
Yeah. Mm-hmm. Evelyn, did you have any supplements in your initial question?
Yeah, can I just
certainly.
Second, convener. So there is the appetite for change, but possibly the way it's been framed is not helpful, but more regulation is needed. What might that look like then?
So the other issue, I think, with regulation as it currently stands is that the Commission are based in Inverness. I think some of their officials are now based remotely, actually, but they're still an Inverness-based organisation, so they don't have area offices, for example, like ARPID do, the Rural Payments and Inspections Directorate. So when the Commission require evidence in a certain case, they ask they have a service level agreement with ARPID. I keep calling them the Department of Agriculture, despite the fact that my entire life they've never been called that. I think it's all the crofters that still call them that. They have a service level agreement with ARPID, and you know, if there's a contentious case, a complex case, they will ask the reporting officers to go and have a look and see for themselves, so they can be the Commission's eyes and ears on the ground. But they're not resourced appropriately to do that. And if we're talking about increased regulation, ARPID are going to collapse under the weight of all of these reports that the Commission are making to them. And there's also the problem of timescale. So as soon as you request a report from ARPID, any application is sort of kicked into the long grass for anything between certainly upwards of 2-3 months, you know, possibly 6, 8, 9 months. You know, it depends how complex the case is. It depends how busy the area office is. And then you've got the issue of the reporting officers who are agricultural officers. That's literally their job. And so they're looking at everything through the prism of agriculture. And so you've got an agricultural specialist or a number of agricultural specialists, these reporting officers as they're called, who are investigating applications which have nothing often to do with agriculture. So if you want to take on a croft and you've got plans to build a couple of pods have a big garden with a polytunnel, maybe some chickens, and you're going to have a little bit of wetland over there, you're going to grow some trees. That would be pretty standard these days for somebody moving into a croft anywhere across the Highlands and Islands, I would say. How is an agricultural officer to assess? Maybe the chickens would be the only thing that would come under an agricultural remit. Everything else is, well, how do you assess that? So it's not really fair on the reporting officers either, and it's not fair on the people who are being reported on, because the person doesn't have necessarily any expertise in what they're doing. So that's, you asked for an answer and I gave you more problems, I'm sorry, but it is a problem, and it does need to be properly thought through in terms of the actual structure of the system. And again, that comes down to what are we looking for from the system? Because once you put pods on a croft, it's never going to be used for agriculture again, really. Once you rewild a croft, it's going to be very difficult to get it back from that to being agriculturally productive again. So it's a problem, and I suspect the genie's probably out of the bottle unless we're going to say, actually, in future, diversification is not, we're not going to allow diversification. I'm not convinced there's a huge majority either way on that. Certainly, it's a different story if you have a large farm and you maybe diversify part of your farm for extra income. You turn your barn into a wedding venue or something like that. But on these crofts, they're so small and so marginal anyway that if you take, you know, a couple of acres to diversify, you're affecting the operation of the rest of the crofts agriculturally, meaning effectively that it will never be used for agriculture again. And maybe that's fine, but that needs to be a decision that's taken at a higher level, not just at the moment it's something that's incrementally happening without any decision having been taken on it, to my knowledge.
Okay. Sorry, just quickly following on from what Ailey said about the pods there. I mean, I would consider that to be an essential form of diversification nowadays for the economic sustainability of a lot of the crofters and crofting townships. Although maybe it won't be used for livestock again, but that's a fact of life. We've moved away from the livestock days.
And finally, apologies to Brian for putting you on the spot with an unclear question.
The numbering confused me.
Okay, that's me, Convener.
Well, I've got a further question for Brian, and it's you highlighted the Crofton Commission historically focusing on residency rather than you know, addressing neglect. How do you think, or do you think this new bill can address that, or how going forward can you ensure? Because we visited Skye and we heard of some crofters living quite some distance from some of the crofts they manage, but were resident in one croft. How do we address that going forward to ensure that we'd get the balance right?
It's very difficult, I think. I mean, it comes back to what I was saying earlier about you know, what resources do the Commission actually have to do that? As I said, they probably tackle residency first and foremost because it's an easy desk job to do. But is it fair that somebody that doesn't live on the croft but cultivates it is being penalised when their neighbour who lives on the croft but neglects it isn't? So, you know, that always seems a kind of unfair balance. And it's probably really a question for the Commission. I know you've already taken evidence from them, but it may be something that the committee wants to specifically ask the Commission, you know, what is the reason why they cannot tackle neglect, and what would they need in order to tackle neglect? It's probably not something that needs to be in legislation, because the legislation is there to allow neglect to be tackled. It's more probably a resourcing issue and making sure that they have the ability to actually do it.
Thank you. Rhoda, did you have a supplement on this before your main question?
And just, I suppose, just following on from what you're saying, I think the Commission are kind of clear that they need people to tell them about neglect for them to be able to go and investigate it. Now, we know that asking the grazing committees to report on what was going on just didn't work. It was kind of clear it was never going to work when that was legislated for. So I think changing it to allow others to report, kind of, I'm not speaking for the Commission, but my understanding of what they were saying was, one, it would take that reporting duty away from the grazing committee, but it would also allow people where they were seeing neglect to report. And it seems to be one of the biggest questions we get is neglect all the time. If you're speaking to anyone, the cross-party group on crofting is always talking about neglect and people, you know, waiting to get crofts and people holding crofts that they're doing absolutely nothing with. So I can understand why the Commission are kind of saying, someone needs to tell us what's going on. We can't know everything unless they've got people in every community, which would be nigh on impossible. Unless folk have got a better idea as to how that could be identified.
Should not have a reporting officer that they were sending out doing inspections on a periodic basis.
It would take them a long time to get round every croft. One person. Not in their lifetime, I don't think they would manage to look at every croft. So should there be maybe a reporting issue as part of the census? Should people be saying what they're doing with their croft?
At the moment, they are asked, are they utilising their croft and are they residents? And I believe it's actually an offence to give incorrect information on that census, but I have absolutely no doubt that many people do give incorrect information, safe in the knowledge that they will never be caught. And I don't know how you square that. So I don't know how you come to an answer on that. So if you've got a regulator based in Inverness with responsibility for, you know, what is it, like 12,000 crofts, when you take grazing shares into account, it's more like 20,000 crofts, because that, you know, each croft or many crofts sort of doubles up almost. So but, you know, if you're just looking at in-buy crofts, I think it'd be about 12,000. So how is one regulator staffed as it is with all of the responsibilities that the Commission have got to do? How are they going to deal with those 12,000 crofts? You're going to have to come up with some kind of a way that it doesn't involve driving to Drumbeg or wherever it might be, from Inverness, in order to find out. And then you would go there, if you were a member of staff of the Crofters Commission, and you drive past the croft and it's well tended and there's a good-looking flock of sheep on there, and you think, oh, brilliant, you know, that's great. But that doesn't tell the whole story. Those sheep might have nothing to do with the crofter. You know, maybe the crofter lives there, maybe he doesn't. The informal use of crofts is absolutely widespread. So driving past somebody's croft and seeing if there are you know, just looking from the roadside, as it were, I don't think is going to work. So I don't know the answer, and I wonder if it might have, perhaps the Commission's network of area assessors might have a role to play here. At the moment, that's an unpaid position. It's a voluntary thing that the area assessors do. I confess I haven't really, you don't hear much about area assessors now, but I believe that there is still that network. And so maybe they can become a sort of, you know, a kind of trusted person within the community. And but then that might end up being a very unpopular role. It could go either way. So it is a problem, and that is the thorny problem at the heart of the crofting system. Unfortunately, it's a regulated system. So how are the Commission to come up with the evidence that they need to make proper decisions?
Okay, Rhoda, can I ask you to move on to your next question?
And we touched on this kind of earlier about the Commission and kind of the length of time it takes to respond. So the bill's taking away the 28 time limit for the Commission to respond for another purposeful use application, but the 28 days stays on the crofter to respond back to the Commission. Is that fair, I guess? Is it reasonable? Is it going to, I mean, my understanding in practice is nobody gets an answer in 28 days anyway, so is that just putting into legislation what happens in practice? Brian?
Response that why no timescales for the Commission but timescales for the crofter, and I think, you know, when crofters are faced with being asked to do things within a set period of time, but then they might wait months, many months in some cases, for the Commission to take the next step, it doesn't seem very fair. And for the Commission to have absolutely no timescale at all, you know, I don't see why that should be the case. I think if you're going to impose timescales on the crofters, impose them on the Commission, and so the crofters know that the Commission are under some obligation. It may be that timescales need to be extended, if so, fair enough, but I think it's inherently unfair to have one thing for the crofter and another thing for the regulator.
So what would you suggest as an alternative? I mean, given that they don't respond and you don't get a decision, or very seldom get a decision in 28 days at the moment, how can we make the legislation work that puts a bit of onus on them but is realistic?
Again, it probably comes down to what I was saying about resources earlier, that if the Commission don't have the resources to actually deal with things within a certain time scale, then how can they be expected to do so? But if it's completely open-ended, then there's no one sitting within the Commission thinking we need to do this by a certain date, so there's no sort of process there. It's difficult for me to say what a timescale should be, because again it comes down to what the Commission can actually manage and what's seen to be reasonable. If 28 days is not seen to be reasonable, then maybe double it. But going much beyond that is probably taking it too far.
We certainly, the Commission reasoning behind this was, or their support of it was, that there were some cases that were more complex, that they would take more than 28 days. But I take your point that that can't be a never-ending process. Ellie, did you wish to come in?
In passing, the Commission at the moment are processing applications probably faster than at any time that I can recall, which is, they should be, that should be welcomed by all of us. There is a problem with consistency of decision making at the moment, and I mean, I talk to Gary Campbell and Andrew Thin, regularly about these things, and it's one of those things that they're aware of and that they're working on, but that is an issue at the moment. So speed at the moment is not the concern. However, I can remember a time when speed was a significant concern, and applications were regularly taking, years, not months. It was absolutely ridiculous. And so, anything that takes away a time limit for the Commission, I'm afraid, does not get my support.
Okay. Thank you. I'm going to move on to questions from Ariane Burgess. Now, Ariane, you had a supplementary on environmental use, and then I've asked you to move on to your questions on Crofton Commission powers.
Thanks, Convener. Yeah, I wanted to come back to the conversation on environmental use, and just maybe it's towards Ailey and Katie. And it was in your responses that this popped up for me, that I'm wondering around that idea of environmental use maybe being something that we need to have in this legislation in order for future support payments. Is that something that maybe it's linked to, that there's something coming down the line that the government has in mind with the changing of how we're supporting crofters and farmers?
My understanding is that at the moment, in order to get a lot of the forms of agricultural support, and I'll just be clear, the agricultural sort of support side of things, subsidies and so on, is not something I'm intimately familiar with, but it's it is already the case that in order to get public money for agricultural activities, a lot of the time you do have to sort of meet environmental objectives, and there's a lot of environmental schemes already. And in fact, just last week we were talking to a crofter from Lewis on our podcast, who was making the point that the small-scale agriculture is actually extremely good for the environment, and I'm, that's not my area. I'm no expert in that, and I don't have a huge amount more to say about it. But she is a crofter and has been for decades, and it's something that's quite acknowledged. So it doesn't have to be; they're not mutually exclusive. Mm-hmm. Environmental care and agriculture do not have to be mutually exclusive.
Yeah, I think what I'm getting at is not that I absolutely agree with you on that. They're not mutually exclusive, but sometimes you need a bit of something in legislation to be able to hook funding on. And so maybe that's something coming down the line.
Maybe.
But that's, the other thing that I was wondering about too is we've been having this discussion about moving towards more environmental some of you have used the term rewilding. And I wonder, right, so that we could go down a track where there's quite a lot of money and time invested in rewilding. And now I'm going to maybe come to Stephen, because I think you brought this up, sparked my mind in we could invest a lot of time and money in rewilding a piece of land, but then how do we ensure that it stays in that state? If the direction of travel is that we're trying to, the point of rewilding is to reduce carbon emissions and tackle the nature and climate emergency. Do you see what I'm getting at there?
Yes. I'm not sure that the Crofting Bill is how you're going to do that. I think that's more in a far bigger discussion on how these sort of schemes work, and things like the carbon code and things like that. And Crofting will, to a certain extent, just be caught up in that. But my understanding of these schemes, as they are fairly long term anyway. I have heard talk about agreements for 100 years for some of these sort of things. So I don't think that's a matter for Crofting regulation. I think that's a far bigger
okay,
question.
but that's very helpful. Thanks. I'm going to move on to my question, which is it's under the theme of Crofting Commission powers, and I was kind of interested in the whole piece around the bill's aim of ensuring owner-occupied crofts. So that the idea is that they can only be the bill will make it so that they can only be held by individuals. But there seems to be some legal and practical problems that could arise from that. So there's some interesting examples where Community Housing Trust is involved in trying to create woodland crofts. So they're trying to do something good, and they would need to hold the crofts as their body. So there seems to me that we maybe need some exemptions in the legislation for that. Ailey, you're indicating.
So at the moment, it is the case that a company can hold title to a croft. So many landlords are companies, limited companies. I think there's a distinction that I would make there between ownership of a croft and the owner-occupier status. So at the moment, it's possible for a limited company to qualify for the owner-occupied status. It's a nightmare getting the owner-occupied status, but if you've got it, you can be a limited company and hold that status. And my understanding is that the change that is being proposed, which I support, is that it will now no longer be possible for a limited company to have the owner-occupied status, but they will still hold title to land. So the situation that you've just mentioned there wouldn't be affected, because that organisation would be effectively the landlord of the land. They wouldn't qualify for owner-occupied status, so they couldn't claim grants in their own name. But I think that addresses your point.
So you don't think that kind of problem that's been highlighted around the woodland crofts is really a problem?
I'm not sure what problem has been identified with woodland crofts.
So woodland crofts pointed out that they were concerned that they've got a project in Glengarry with Community Housing Trust, and they want to set up a number of new woodland crofts that would be created for owner occupation, and they would have a rural housing burden attached to the whole croft. And in order to do that, CHT would need to be would need to hold that before onward sale could happen. So they're kind of like sitting in the middle of a process, if you see what I mean.
I don't believe they would need to be owner-occupiers, though. They would need to own the land.
Right.
But I don't believe that...
yeah, okay, so
absolutely. And actually, at the moment, it's always been the case, actually, that a tenant crofter must be a single natural person, so not a corporate person, not a company. And at the moment, it is definitely the case that the allowance, if you like, of limited companies having the owner-occupied status, it is being abused, because the owner-occupier crofter would have to comply with the statutory duties. But if you're a company, you can be based wherever, and there's a number of, you can employ somebody locally, you can have one of your directors who's complying with it. So it is a kind of door to an abuse of the system at the moment.
Yeah. Can I just add, I've got another example. So with this, if this comes in, is it into the future? And so, for example, Fair Isle is owned by, Fair Isle is owned by National Trust for Scotland, and they have lots of crofts on that. So is that a similar situation where they own the land, but they're not the owner-occupier?
Yeah.
Okay. Brian.
I'm not sure entirely about the example you were given, but I think it was an example of where a trust is the owner-occupier, they own the land and they're occupying the land, and they want to carry out some crofting activity, in that case, trees. I'm assuming from what Ailey was saying that Ailey was looking at separating that, because if they can't be an owner-occupier, because the legislation suddenly doesn't allow it, but that would be on a transfer, I think. So there'd be a period of time, if at the moment they're an owner-occupier, they could continue to be so because they are they own the land. This provision is for future transfers of the land. But that could also affect a body like that who wanted to buy more crofts for a useful purpose, maybe neglected crofts or whatever. But they might be able to then buy the land, but they would have to put an individual in some form under a short lease or as a tenancy, and that might not suit their make-up or how they're funded or whatever else. So there may be unintended consequences there, and that's maybe something that should be considered and looked at, whether there could be some regulatory ability to allow the Commission in certain circumstances to allow a non-natural person to be an owner-occupier if they could see there was some purpose. That may be a way to facilitate that. But separately on the same topic, I'm slightly concerned, and I didn't raise this in my written evidence to the committee because I hadn't noticed it at the time. But since that, I looked in a bit more detail, and looking at clause 10 of the bill, it states that after the relevant date, any transfer of the title to the croft to a person who is not an individual is null and void. And I think that may have unintended consequences, because that sounds, when you read it, like you're speaking about one individual, not maybe several individuals. And throughout the history of, since the right to buy was allowed, it is very common for a crofter who's an individual tenant, obviously, to purchase the croft maybe in joint names so that the two spouses own the land. And there's lots of crofts at the moment that are in multiple ownership, family ownership. It also allows for greater ability for succession, where maybe parents can leave a croft to 3 children. I don't think this is the intention of the legislation. The intention of the legislation is to stop non-natural persons from owning crofts. But the way it is worded at the moment could be misread, misconstrued. You could have a situation where people are saying that just means one individual. And I think the wording needs to be changed from person to natural person or persons, so that it is clear, there's a clear definition for what a natural person is. And I don't think we should be using in the legislation the word individual.
Okay, thank you. Alistair Allen.
Thank you. It's probably a related point, but I know that the section, we're talking here about section 10 of the bill, are we? Yeah, so I know that that's a section of the bill that the Law Society have raised concerns about. You possibly answered some of the questions that there are to be answered on that, but I wonder if Chris from the Registers of Scotland could offer any perspective on section 10 of the bill and the issues raised by the Law Commission.
Yes, so I think it's possible that there is slight confusion around it. I think listening to colleagues on the panel, it sounds to me like section 10 is dealing with transfer of the title to the croft, so not transfer of the underlying ownership, which I think sounds that the position would be that a transfer of the underlying ownership into a non-natural person would remain possible, but they would then need to cease their status or that status as owner-occupier crofter would need to change. So I think in some of the submissions, I think there was a view expressed that what was struck at was the transfer of the underlying ownership, that would be null and void. I think that is probably not the case, but it might be helpful if that's clarified, I think.
I think it was the Law Society's response that had concerns. Can you maybe set out those concerns? And it may have the opportunity for Chris to come back in and address them.
Yeah, thanks, Convener. Yes, I think I would take a different view to what's been expressed here. I think the new 19BB2 would make the transfer of the title null and void if it was an owner-occupier croft. The process that Ailey described, I think, is what we were expecting the bill to say. The title could transfer, but not the owner-occupier status. And I think that would probably sort out the problem that was being raised about preemptions and rural housing burdens and things like that. The other concern we have about this is how it gets policed. My understanding is that the registers don't normally check deeds to see if this is a very similar provision to another one about transferring part of an owner-occupied croft. The keeper doesn't check those. So a lot then gets put on solicitors to check those. And our question there about Section 86 of the Land Registration Act is if one of these gets through and a title sheet is issued, Section 86 says, in effect, that a good faith purchaser can rely on what the Land Register says. So if these get through and a title sheet is issued, have we just managed to get around this because nobody's looking at it?
Chris?
So I think that will turn on, I think, what the legislation is attempting to do. So if it is attempting to stop the underlying ownership title being transferred, then I fully agree those issues are engaged. If that's not the case, and what it's attempting to do is allow the underlying ownership status to be transferred, but require a change in the owner-occupied status, owner-occupier status, then I don't think those issues are engaged. So I think it's fundamental to understand what the intention is around the drafting. I think if those issues with the title are engaged, I would say that in the general circumstance, the keeper, when processing land registration applications, will rely on the certification of the submitting solicitor. The submitting solicitor will, of course, want to ensure that their client is achieving good title. So one of the reasons why the keeper relies on the certification is because in a typical transaction, the deed and the money will change hands a short time before the application is made to the register. So you do want to identify problems before the registration stage, because once you're at the stage of registration, it's actually more difficult to resolve that problem if there's some fundamental issue with title. So the reason that the keeper relies on the certification is because the lawyer has an interest in ensuring that their client achieves good title, as they would in this scenario as in others, I think. I think that the point about Section 86 in terms of Part 9 of the Land Registration Act 2012, I think that would on the face of it be engaged. And so if you had a situation where a limited company or some other non-natural person was on the register, on the land register, as owner, but actually, according to underlying property law, they were not the owner, then a good faith purchaser would be protected and would be able to achieve title from them. The company or the non-natural person itself could not achieve title, but a good faith purchaser from them, a further transaction, that person could achieve good title. I think that would be the position, but I think it does turn on the first point about what is actually trying to be achieved by the legislation.
Brian?
It may be that, from what my colleague has been saying, that it's simply a case that if the owner-occupier status is the real issue here and not wanting incorporated parties to be an owner-occupier crofter, that the legislation needs to be changed to simply state that. So it's not hitting at the ownership or voiding ownership that goes to a corporate body, but just saying that their owner-occupier status would be removed. And that on registering that transfer in the crofting register, that the status would be amended to take away their owner-occupier status. And that maybe solves the issue.
My understanding of this change is for grants, correct me if I'm wrong, the purposes of grant funding. So tenant crofters and owner-occupier crofters have access to agricultural grants. The landlord, underlying owner of the croft, does not. So by specifically defining it and specifically stating an owner-occupier has to be an individual person, you're effectively closing the door to companies or trusts or whoever to have access to the grant funding that owner-occupiers and tenant crofters enjoy. So that's...
But if you remove their owner-occupier status, then that should resolve that problem, because they're no longer an owner-occupier, so they wouldn't be entitled.
Absolutely, yeah, that's how I read it.
I look forward to reading the official report and get my head round this. But thank you. It's good to get that on record, because we're just uncertain what the specific issues with it from the Law Society was. So that's helpful. Rhoda Grant.
I'm really just... This bill is, I guess, tidying up an awful lot of the things that happened that were wrong with crofting, and Ailey was saying it's kind of a bit boring, and possibly everyone's looking forward to a bill that actually deals with the policy issues. But are there any other tidying up issues that need to be done?
Do you mean tidying? Do you mean things that are not in the bill at the moment, like extra things?
Yeah.
Let's remove the right to buy, for example. Yeah, I mean, probably if you were to go through it, with a fine tooth, I'm sure you could come up with others. But it does tidy many things up, and yeah, with the exception of the provision on grazing shares, I'm sort of generally supportive of what's been proposed.
Okay, we might come back to this right at the very end once we've asked some questions and there's some points we haven't raised.
Sorry, I'm jumping ahead. Apologies.
Just a little bit.
Just a little bit. I'm going to get around.
Not at all.
There's a proposed 10-year restriction under Section 11 to make sure that if the Commission resumes a croft and then assigns it to a tenant, that tenant cannot sell that assignation for 10 years. Does that strike the right balance? Does that stop the trade in crofts? Does that, I guess, stop the Commission being accused of giving an asset to someone that they suddenly capitalise and we know the value of crofting assignations?
Brian and then Ellie.
In my written response, I was concerned that there might be situations where that could cause problems. I said, what if there is good reason requiring the consent to an assignation within 10 years? And I gave some examples. For example, on death, divorce, ill health, or family reasons requiring a geographical move. So there could be things that happen that don't make it sensible to be compelled to remain for a 10-year period. And I suggested that there should be a process allowing for exceptions to this rule in reasonable circumstances.
Okay. And my understanding is that it reverts back to the Commission if that were to happen. Would that deal with that issue if there were exceptional circumstances?
Well, there may be no reason why the current tenant shouldn't be allowed, you know, if it was a family transfer or something else, to assign that lease. And I think the Commission should be able to look at that on a case-by-case basis and take an approach that's linked to the circumstances.
Okay.
Ellie?
With any of what Brian's just said, apart from the last part about perhaps the person who needed to sort of, you know, make the break with the croft and move on in a different direction in their life. My own opinion is it would be much simpler just to provide them that they had to renounce the tenancy and the croft would then become vacant and the whole process would start again. Because otherwise, if they then choose to assign the tenancy onwards, they can do so in the same way that anybody else can, which is to say they can charge a consideration for doing that. And I think I think that would go down like a bit of a lead balloon if the Commission were letting tenancies for nothing. Because when the Commission let tenancies like that, there's no money that changes hands. The Commission are blind to the market in tenancies, which of course is one of the problems that needs to be addressed in future legislation, in my own view. Commission lets are very rare. I don't have the figures. No doubt the Commission can provide those. But this is so this alone is fine, but it's not going to resolve any of the problems with the market and croft tenancies, I would say.
Okay. Tim Eagle.
Convener, and good morning. So just a couple of quick questions, if that's all right. One on decrofting and then on boundary changes. If I start with decrofting, my understanding is the bill does two major things. One is removes decrofting without a stated purpose, and the second one is limits the right to decroft a house to one per crofter. Do you have any thoughts around that?
Ellie?
Yeah, fine to both. In practice, there isn't a real, at the moment in practice, there is no right to decroft that isn't reasonable purpose. You can submit an application, but you're going to get nowhere with it. So it is literally just tidying that up. And yeah, the limiting of decrofting, you know, is fine and quite sensible.
Okay. Any other thoughts on that?
I think restricting decrofting to one decrofting per croft is not going to be conducive to building communities going forward. Crofting communities now do not just consist solely of crofts. There are multiple people living on crofts built in houses built on plots that have been decrofted, and I think that really needs to continue, particularly as well if you've got like a crofter and he's got a young family and his family want to stay on an island or in a crofting township. He needs to be able to decroft a site for these kids to give them any chance of getting on the housing ladder in the rural areas nowadays. So I think it's a bit too much to put a blanket policy that you can only have one decrofting per croft.
Sorry, I've maybe not fully understood that then. So this is about land for a house as well as much as it is a croft, a house that is already on a croft. No. Just say that again. So, yeah, sorry, I've misunderstood this. This is about, so if a croft, sorry, no, I'm going to stop my question. I think I understand what you're saying. I think crofting law is tricky. Can I move on to boundaries boundaries being remapped then? Because I think, Brian, you said that this is a recipe for disaster. So can you explain that a little bit more?
That was section, I think I had 2 recipes for disaster. Which section?
Section 30, no, section 14, no. Yes. 14A.
Yeah. Yeah, that was the recipe for disaster. It was section 26 was a can of worms. So, so we'll look at the recipe for disaster. So my concern here, and Chris might be able to comment on this after I've commented on it, but was that we have a situation where we are looking at amendments to the crofting register to reflect what the occupied extent may be. And at the moment, we've got the land register, which shows the title position, and we've got the crofting register, which shows the crofting position, and the two often don't match. But if you get into a situation where you have managed to match the two, so you've got an owner-occupied croft, which is clearly defined on the land register, and that owner-occupied croft is also clearly identified on the crofting register, or you have a situation where you've got just a crofting register showing an occupied extent. But then we start to fiddle around with that. So we start to say we're going to start moving our occupied extent, and we're going to change the boundaries on the crofting register. And that's allowed, and the occupied extent changes, but the title extent doesn't change to correspond with that. It's all going to be very messy. It's all going to be very difficult for everybody to know what's going on. And I think the two need to be linked in some way, that if you are saying, I have a different occupied extent from what the situation is here, is that reflected in the title boundaries? And if you are saying your occupied extent as a crofter is different from what your title extent is, should you not be sorting out your title extent first, rather than sorting out your occupied extent, which is then going to conflict with the ownership position? Hopefully I've explained that okay, but it gets rather complicated. I just think that the two need to be linked, and you shouldn't be looking at being allowed to amend in the crofting register occupied extent if that's conflicting with title boundaries, and could potentially be introducing other landlords because there's a neighbouring croft that you're now saying that you're part of, that's not been reflected in the crofting register, you're bringing in another part landlord. And really, I think the need, if there is a need there, would be one that is also linked to correcting title boundaries, not just occupied extent. And there should be some linkage between the two.
Okay. Yep.
Yeah, we would agree with a lot of what Brian said there. I wonder if maybe this could be dealt with in this similar sort of way of an advance of purchase decrofting direction. So a tenant can go to the Commission, get a decrofting direction for a site that kind of is pending until he buys that site from his landlord. That sort of thing, I think, could work and could bring that kind of linkage that Brian's talking about, that you would go to the Commission and say, we want to do this. Commission say, that's fine, away and sort out the title, and then this will become good.
Okay.
Chris.
I guess just a couple of comments on that. So I do think ideally you would want the registers to correspond with one another. That's certainly, I think, the ideal position. But I do think you have to acknowledge that getting them to be exactly in line is a challenge for some of the reasons we've mentioned. I would say that the provision that's in the bill around new section 39A, so section 14 of the bill, I think does, as Brian says, have the potential to move the crofting register out of line with the land register, but conversely I think it also has the opposite potential. In some cases it probably could serve to bring the crofting register in line with the land register. As I read the policy memo, I think the assumption is that where parties use this provision to move crofting boundaries, it would be in their best interest to then carry out conveyancing in order to bring the land register into line. Whether that's a likely assessment of people's actions in those circumstances, I don't know, but I do think that is what the policy memo seems to rely on, that parties it will be in their interest, and therefore they will take the necessary conveyancing steps to bring the land register into line with the change that they've made to the crofting register. I would say in general my experience of this sort of thing is that the difficulty tends to be in getting people to agree rather than in the mechanics of conveyancing. The mechanics of conveyancing tend to be fine. I mean, you know, they can be expensive or they can take a little bit of time, but they tend to be okay. The challenge is normally in getting parties to agree. But 39A inserted by section 14 is premised on the fact that you've already got consent of the parties. So that does, I think deal with some of it. But there is, I think Brian is right to say, there is still the potential for parties not to follow through on the land register side of things, and to move the two registers further apart in terms of their reflection of the position.
Okay, thank you. Oh, Ellie.
Very briefly there, I don't disagree with anything that has been said there. One problem with the crofting register is that it is a mess, really, at the moment. I would say probably in at least 50% of all cases where you look carefully at a croft registration, the way that the boundaries of a croft have been registered, they're wrong. And that figure probably goes up to 80 or 90% with an owned croft, because that's when the matching or the mismatching, as the case may be, of the title boundaries and the crofting register will happen. So that might well be something, as just to come back to Rhoda's earlier question about is there anything not in the bill which you would like to see, and maybe it might well be one for another day. Maybe there's something in there about tightening up the procedures around croft registration, because it can be really tricky to change the boundaries once they've been registered. And again, you need cooperation and agreement, which is sometimes lacking. So that's a problem at the moment, is the crofting register.
Can I just, thank you for that. Can I just come back to my previous point now? I'm trying to get my head back into gear around the house sites. Now, because I'm not an expert in this. So to my understanding is you can build a house, can you not, on a piece of croft land? So there would be nothing in your example, Katie, from stopping another family member building a house without needing to decroft that land?
Yes, the funding of it. So you can't raise mortgage finance,
right. Okay.
Unless you have...
So you could do that with private funding, but you couldn't take a mortgage to do that?
Well, you can get... If the crofter themselves can get a grant of around £37,000 towards building the house, but it needs to be croft land at that point. But you can't build a house for £37,000.
No, I wish you could.
So generally speaking, if you've got a child who wants to build a house on your croft, you have to decroft that house site first. If you're a tenant crofter, you have to get title from the landlord. If you're an owner-occupier crofter, once it's decrofted, you can then transfer title to that plot to your child, who can then raise mortgage finance and build their property.
Okay. So Ailey, if you don't mind then, not to try and put you in contract, but you said you were fine with that then, but that kind of makes sense, does it not? That actually, if we want thriving rural communities, then actually surely that doesn't work then. So why would we want that in the bill?
So, I mean, you can put whatever you want in the bill. I suppose the point that I was making earlier was that you can't have everything. So you can't have croftland as housing stock and also have it used as environmental land or for agricultural land. So that, I suppose, is one for Parliament ultimately to decide what is the policy priority here, what is the point of the crofting system, and then hopefully a new bill can be introduced which has that at its centre. The problem at the moment is that there is no clear idea, and the Commission are having to, at the same time, support local population retention, which means housing, I would, assuming.
Maybe the point you're making is, do you want people or animals in rural Scotland?
Yes. I get that. I wasn't clear on that, but I'm clearer now of what you're trying to get out there, so thank you for that.
Thank you. Before we move on to common grazings, I'm minded to suspend for a comfort break for 5 minutes. Suspend the meeting. That's all right. You're sat. That's it.
Like if you take Lewis as an example, you would have great
Okay, we now resume our session in the Crofton and Scottish Land Court Bill, and we've got questions on common grazing from Alistair Allen.
Thank you, Convener. One of the things that's going to be of interest, I think, to the committee is the whole issue of unattached grazing shares or deemed crofts, and it might be helpful if somebody on the panel here can just take us through the history of how that situation came to be, where the two could be divorced from each other, and then we can talk about what happens next.
So basically, an unattached share, when crofters were able to purchase their crofts first, there was no legal definition of owner-occupier, but we all called the croft owner then the owner-occupier. The share itself broke off. It remained in tenancy, but it broke off, and in terms of the Acts, is classed as a deemed croft in its own right. That's its technical name. Over time, what's happened, maybe the in-by croft land, the owner-occupied croft itself, has been transferred to a third party. They've forgotten about the share, particularly if there's been a death. They've transferred the croft, they've completely forgotten about the share or didn't realise there was a share, or they just didn't include it in the inventory for confirmation, and that share remains in the name of either somebody that's deceased or somebody living abroad, or just, you know, an absentee. So there are quite a number of these unattached shares floating around. I think since the 2010 Act, they've actively tried to encourage that they don't separate the share from the in-by croft land itself, but just the practicalities of dealing with the transfer of the share. It's expensive and people just don't want to pay for it, and it doesn't happen.
Okay.
So when a conveyance is granted, you have a tenanted croft, tenanted in-by land with a pertinent of grazing, which is the grazing share. When you purchase your croft land, your tenancy over the area that you take title to, so the area defined on the conveyance, on the plan, the tenancy over that area is extinguished at the point of registration. So you've got an owned croft, hopefully an owner-occupied croft if you're lucky and you comply with the definition. And you also, at that point, have a tenanted grazing share. And for a long time, the Commission didn't reflect that separation in their register of crofts. And so, and most crofters, when telling the Commission, I've purchased my croft, the Commission would say, did you include the grazing share? And they would invariably say yes. And of course, in most cases, they didn't, because for the grazing shares to be included in the conveyance, it must be listed in a conveyancing clause within the deed, in the parts and pertinence clause of that conveyance. And mostly, it isn't. So in order to bring some clarity to the situation, the Crofters Commission brought a reference to the Land Court in 2012. Lots of questions about what happens to the grazing share, should we be treating them separately, etc., etc. The Land Court determined that Land Court struggled with it, actually. It was, a few days in the Land Court listening to debate about it. And the result of that was the Land Court did recognise deemed croft, and they said, yes, they are separated at that point, and the Commission thereafter started changing the register of crofts, which is why the number of crofts has gone up so significantly from like 12,000 up to over 20,000, because a lot of the time that extra number is accounted for by the grazing share being a separate entry in the register of crofts. And the current proposal, my understanding of it is that it will effectively mean that if the conveyance doesn't specify either way, so at the moment the position is, if the conveyance doesn't specify either way, the grazing share is separate. If the grazing share is specified in the parts and pertinence clause, it becomes what the Land Court have called a quasi-servitude. So if it's separate, we know what happens. It's a deemed croft, it's got its own entry, we know how to deal with that. It's not ideal, but it's established. If it is included in the conveyance, it's called a quasi-servitude, which the Land Court, obviously, that's not a thing. A servitude is a thing, but a quasi-servitude is not. And so the Land Court obviously struggled to define it in legal terms. And I suppose my concern with the current proposal is that it will, by default, mean that the grazing shares are included rather than excluded by default. And if that happens, you're going to end up with an awful lot more quasi-servitudes than you currently do. And I mean, how does I probably shouldn't ask questions, sorry, I must go through the convener, but I don't know how the registers of Scotland would deal with all of these quasi-servitudes, how they would appear on the register. And personally, if it was me, if I was buying my croft, I would prefer to have a deemed croft. It's not ideal. Nobody wants the separation of grazing shares from crofts. But that is the situation that we've got. And it is the lesser of two evils to have the current situation that is understood in legal terms than have an amendment really just for the sake of it to say, oh, we're resolving that problem. But you're actually creating another problem because what exactly is a quasi-servitude? Nobody really understands.
I had hoped that would simplify matters. I'm not sure it does, but I'll bring it, if I can, bring in Brian.
So, these quasi-servitudes, or I just prefer to call them as appurtenant, are, and Beatrice will know this, are very common in Shetland. So, most croft transfers in Shetland, unlike the rest of the country, involve the landlord agreeing to grant in the title, in the parts and pertinence clause, explicit reference to the grazing share being carried with the title. So more often than not, if you're dealing with a property in Shetland, you will find that the grazing share has been attached and is never separated because it's been attached at the point of purchase and forms a part and pertinent of that croft. And that means that in any future transfer of the croft, the part and pertinent grazing share just goes along with it. So there's not this separation happening. And that separation has really happened in most of the crofting counties out with Shetland. I've no idea why that should be the case, but it was probably just a conveyancing procedure that was adopted by the firm that acted for most of the landlords in Shetland historically, and they just continued that through by including it as a part and pertinent. And that doesn't really cause any problems. It actually solves the problem of the separated shares, because it means that the share is attached at the point of purchase and remains with the croft and is not separated. It avoids the situation of having that held as a separate entity, which is a separate leased entity. It resolves issues such as succession or joint ownership, because if husband and wife buy the croft, the share is included in that title to husband and wife. If they then leave it to their 3 children, that share is part of the title that the 3 children have. Whereas, if it is kept separate as a deemed croft, it can only be held in the tenancy of one person. So you then have to decide anyway on a purchase where there's a deemed croft involved to separate effectively the person who holds that, because you may have husband and wife having title to the croft, but you then have to choose between husband or wife having the tenancy to the share. So there's a separation that happens naturally anyway, or unnaturally perhaps. And my view is that the Shetland model actually works very well and is one that should be looked at and considered as a method for ensuring that the shares are attached. The difficulty I have with the way the bill has been worded is that, although, as Ailey says, it reverses it and says unless you expressly exclude it, it will be included, whereas in Shetland it's expressly included on a regular basis and so forms a part and pertinent. It's not forcing the issue, though, because it's a question of choice still, and a landlord can still say, I'm expressly excluding it. And that's exactly what's going to happen, because landlords have been used to excluding it by not having to specifically state that. They are now going to say it's excluded, and it'll just be excluded, and you will still have the same problem carrying on forever, and there'll be no clarity, which is, the policy decision here, I think, is that we want to ensure that the shares stay with the croft and possibly can be reattached, and I'll come on to explain how that could happen. So I think that if that is the policy decision, there needs to be more of a compulsory element to this, and it needs to be a question that when somebody purchases their share, the share will, in the way it happens in Shetland, will be part of that transfer. So a purchase, you won't be able to include or exclude it, it's just going to be included, and you make that a compulsory element of a purchase. So any crofter can purchase their share as a part and pertinent. The issue of how that might appear on the title is already something that I covered in an article some time ago, following discussions with Registers of Scotland and the Crofting Register. The Land Register does not show those pertinents within the Land Register, but the Crofting Register will show that it's part of an owner-occupied croft, the share. So it's just important that that whilst the title deed at the moment, a Shetland title deed, once it's, although it might specify that the shares include it, once it goes into the Land Register, the title sheet doesn't show that. So you always have to look behind the title and look at what the disposition said when it was granted. But a conveyancer can do that, and as long as they're doing that, they know it's a part and pertinent, and if it's shown in the Crofting Register, that is covered. And likewise, if you allowed a system that made it compulsory, you could then include the ability to reattach these floating shares by giving the crofter the ability to purchase as a pertinent the share that is floating that used to be part of the croft. So they could bring the two together, and you would end up, over time, it'll take a long time, but you could end up over time resolving this problem, because all shares would be reattached and all shares would be linked to an owner-occupied croft.
Thank you. Come back in again on some of this, and I suppose, would it be fair, maybe I'll address this to Aileen and anyone else who wants to come in, but would it be fair to say that the situation being described here is that outside of Shetland, many of these situations have happened, as it were, by accident rather than design? And do you feel that the bill is more designed to correcting situations that happen by accident rather than design? But if I can bring in, if I may, convener Aileen wants in, and then Katie, I think.
So Shetland, Brian's absolutely right. The grazing shares being included in dispositions is really common in Shetland. I would just point out that my own experience of dealing with, I don't deal with registration of title, and I haven't for a few years now as a non-practising person, but I do work with firms who do register title, and our experience has not been a positive one. And you've just heard Brian say actually that the keeper will not, this pertinent, this quasi-servitude will not be specified on the title sheet. So I suppose I have concerns about that. And yes, we should all look behind the Land Register. That's not quite as easy when you're dealing with conveyancers you've got a land certificate and they're saying, well, there's no grazing share on this, so what am I? And then you have to give them a sort of mini lecture about, yes, well, it was attached and, you know, you've got to take my word for it, etc., etc. So it's not, I'm sure it does work in a lot of cases, but I don't think it's to be encouraged going forward. And I think what would end up happening is probably litigation about, you know, to get to the nub of what this right actually is or was.
Yeah, in my experience, it's the crofting landlord that was reluctant to allow the share to be sold with the imbibed croft land, so they didn't want the ownership of the share to pass. They wanted to retain full control of the hill, although there's one or two conveyances where it is included as a pertinent, but it hasn't happened. One thing we do need to be mindful of is that, I mean, a lot these shares historically maybe haven't really had much value, cash value. Crofters maybe trade them for £500 each or whatever if they've got a lot of cattle and they want to put them all out in the hill. However, going forward with the other sort of changes proposed to uses of common grazing, and particularly where you've got maybe a very well organised sheep stock club or you know, grazing committee, these shares could become quite valuable going forward, particularly if there's a significant woodland development, wind farms, any of these things. So whilst you know, it sounds great just to reattach the share, put it in legislation and let it happen. I agree with Ailey here. I think you could be looking at, you know, significant litigation from people there.
Crofton law is incredibly complex and there's lots of history behind it. You've sort of got to understand the history to understand why we're at this point. Is there not an argument that when the Crofts were split up, you know, and I'm a lowlander, so I'm new to this, so we're looking at a township that maybe has 50 crofters and they all have 15 acres each, but to make that croft viable, they then got a share in a far larger a hill, 5,000 acres of hill to graze. So the viability of that croft was absolutely linked to those grazing shares. That link has now been broken, deliberately or not deliberately, but you know, as Brian said earlier on, is there not an argument that we should be seeing the croft, the physical croft, tied into those shares to continue to have a viable unit? And also avoid the risk of land banking, if you like, or right banking, where a 500 or 5,000 hectare hill has the potential to have wind turbines, peatland restoration, solar panels. So those shares that used to be worth very, very little now have a bankable value now or in the future. So maybe Brian's saying about legislation to pull them back together. Historically, that would have been the right way to do it. But I'll bring in Brian, because I've mentioned Brian's name, and I'll bring in Stephen.
So, Katie said that the landlords often want to retain the share and create it as a tenancy because they don't want to give up their common grazing. They're not giving up their common grazing. So I think that's a misunderstanding, because they still remain owners of the entire common grazings, because this is a pertinent, a quasi-servitude or whatever, but it's no different because it's treated in the legislation as just a share in the grazing. It's a right to use the grazing. So the ownership position does not change. So this doesn't really affect the landlord in any way, apart from the fact that they might, you know, when a croft is sold and the deemed croft is retained, there'll be a rent ascribed to that grazing share, but that rent will be small. And the landlord's going to have to collect a small rent for a grazing share, whereas if it was included, that value in part and parcel at a purchase, they would get a capital sum that reflected that. But as far as the future goes for that landlord, there's no effect on any development on the common grazings. It's still the same position. If a wind farm developer comes along, they are still doing a deal with the landlord, because the landlord still owns the common grazings. And the pertinent, which is no different from having the tenanted deemed grazing share, still gives the crofter the right to receive half the development value of that land over a period of time. So the actual legal position is not really any different on a day-to-day basis. The landlord is not giving up an ownership right as such. They're just allowing the grazing share to become a pertinent, which is the ability to use the grazing. It's not an ownership, a fundamental ownership title right as such. So I think people need to get that sort of clear in their heads. And once you do, you can see that the Shetland model actually has worked in Shetland for many, many years without problem. And if you've got an example there that you can utilise, why not utilise it? Because it's an example that works in practice. And I think there's a lot to be commended for it. And I do not believe that we're going to end up in lots of litigation over it, because there's been no litigation that I'm aware of in Shetland over these shares and what their status is. Everybody understands, and it's clear in law, and on the back of the reference where the Land Court did clarify a lot of these things, as Ailey said, in 2012, the law is a lot clearer as it was before that date. As a result of that, I think it's fairly clear. There may be a few things that need to be clarified still, but on the whole, people understand how that works. And I think if the policy, as I said earlier, is to reattach shares, that's a clear way to ensure that it's done.
Stephen.
Thank you. We don't have a particular position on which of these options should be chosen. That's a policy question for others. But I think our main point in this was the point that Ailey mentioned a while ago about a quasi-servitude. That's, as she said, not really a thing. So in a tenancy, we've got lots of landlord and tenant law that we can draw back on. With this, I think we need to be thinking about what is the relationship between the owner of the grazings and the crofter exercising that pertinental right. That comes to things like we've mentioned in our written evidence, a case that Brian was involved in Shetland, where a crofter holding one of these rights took an apportionment, and the Land Court has now said that that apportionment is now rentable again because he's taken an apportionment. So while we don't necessarily have any objection to this being done, I think we need the background filled in because we don't have that background from the general law to fall back on.
Katie, did you want to come in?
Yes, sorry. I was maybe a bit unclear about the landlord situation. No, there's no ownership of land passing, but there'll be no more rent collected. Maybe was perhaps a better clarity on it. I think if you're going to do this exercise of where you're going to reattach a share, you would need to specifically state in which scenarios it was going to take place. So if you've got shares that are vacant, it would be quite easy in the legislation, I would have thought, to just state that it now reattaches to the original croft it pertained to. Or if you've got at point of death, it transfers then back to the original croft. However, that's the scenario where I'd envisage that you might have a beneficiary in the background who thought they were getting a big cut of wind farm money, who might then be raising. But I mean, if it's statutory legislation and it happens automatically, then they wouldn't really have any case to answer for that.
Okay, Rhoda.
It's about those shares that are kind of out there now and have been separated, and possibly people aren't even aware that they have got a share.
It's very expensive. Like if there's been a death and the share's forgotten about, I mean, it's £2,000, £2,500 the legal fees just to attach a share back to. So, I mean, if you can put it in the legislation, it would simplify things for a lot of people.
So how would we do that in legislation? Given that some, like you said earlier, that some people know they've got the share and it's floating there and there's something going on in the common grazing that's going to bring them an income, but on the other hand...
So at the moment, practically, the shares aren't generally separated. If you buy your in-by croft land, you become the tenant of the share, you continue to rent the share. It's just in certain scenarios, the share is in third-party ownership or it's completely vacant, then the legislation could be written to state that any vacant shares are reattached specifically to the croft that they're originally related to, and then at point of death of any other unattached, any other shares that have become separated from the croft, that they then automatically revert back to whoever is in control of that croft. And obviously the scenario in Shetland is different. I'm only talking about the ones that we generally deal with where the share has not been purchased as a pertinent to the croft.
And that wouldn't have a cost attached if we did that in legislation?
It wouldn't have, sorry?
A cost attached.
Not that I can...
There'll always be a cost. Right.
In a situation where you were saying it'll reattach, you have to remember that this share at the moment is a deemed croft held in tenancy, which might be in the name of one individual, whereas the croft is owned and there's a title to it. So there's two separate types of entity here, so it's not easy just to say we're going to reattach it. There needs to be a process to turn that tenanted right into a heritable right. So it needs to be almost like a right to purchase on the part of the owner of the croft, where the deemed croft has been separated, and there's some right for them to seek to acquire that.
the Act's going to define an owner-occupier can only be one individual, then it would attach to that individual. Obviously, you couldn't apply it retrospectively because a lot of crofts have already been divided out multiple ways.
I think we'll seek further guidance on that before we speak to crofting stakeholders. Oh, Ailey.
I promise I'll be really brief. Just to say, this bill started out life as an amending, a technically correcting bill. And during its journey, there was several things thrown into it that were sort of resurrected from a previous time. There was standard securities, made a reappearance, joint tenancies and grazing shares. And most of those things that had been sort of put into what was supposed to be a tidying up bill have now been dropped again, in my view, correctly. But this provision on grazing shares is one thing which the danger is, and you've all heard how complicated it is, it's really difficult. And the danger, in my opinion, is that this is more tinkering. And this is the problem with crofting legislation at the moment, and has been for decades now. And the more tinkering you do, you could spend a lot of time thinking up a fudge about common grazing that people are happy with and people can sign up to. And ultimately, it's still going to be a mess. And it's going to be a mixture of several messes, in fact, because it's one thing on top of the other. So my own preference is to have that taken out of the draft bill. And common grazings, which are ripe for serious reform. The model is completely outdated and doesn't work for anybody. So it's ripe, really, for, I suppose, assessment in terms of what are we doing with the crofting system and what kind of a system do we want for our country. And I don't think this is going to help us get there.
Okay, thank you. Beatrice Wishart.
Thanks, Convener. Good morning, panel. My question was actually going to be around asking about the governance and use of common grazings and whether the changes provide sufficient clarity, accountability and legal certainty. And I think from what we've heard already, I think Brian's reference to a can of worms, I think there's more than one that we're looking at today. But if anybody wants to add anything to what's already been said, happy to hear that. If not, I would like to ask a question that actually relates to Shetland. A few years back, there was an application to establish a community woodland on common grazings, and that obviously involved contact with the Crofting Commission and Scottish Land Court, and I'm told it cost £500 and took 8 months to conclude. A constituent involved in that process suggested that decision-making on that type of land use change should be devolved to relevant grazings committees. I'd be interested to hear the panel's views on that. I don't know who would want to go
I'm looking
first.
at Brian, given it was a Shetland example.
It's not something I've had to think through, so I'm a little bit on the spot. But I think there's probably dangers in devolving regulatory powers to grazings committees, if that's what's being suggested. We have a regulator, which is the Commission, and I think they should be the ones that are regulating. They should maybe be listening to what the grazings committee is saying. But I think we would need to look carefully at whether, and often grazings committees, for one reason or another, don't agree with what's being proposed to be done on a grazings anyway. So I'm not sure how well that could work. But it's not something I've had to give a lot of thought to, I'm afraid.
Katie?
Yeah, grazings committees generally, they're only in office for a 3-year period at a time. So, they've only got a short window of control over what goes on in the common grazing. So I wouldn't be encouraging giving them any more powers in that regard, no.
Okay. Any other comments?
Can of worms comes to mind again.
Cooking a can of worms. A recipe for a can of worms. Something like that. Beatrice, do you have any further questions?
No, that's fine, thanks. Thanks,
Okay.
Convener.
Thank you. We're going to move on to the Crofton Register and questions from Emma Harper.
Okay. Just a quick question before I ask that. When do grazing committees meet? Is it required that it's every 6 months, every whatever, over the 3 years?
Depends on your township. So the townships are all very different. Some villages, the grazings committees will meet once a month. They will have little subcommittees on them that are dealing with certain aspects of it. If it's a particularly large township, 65 crofts or more, then they're generally a lot more organised, but it's township to township. Some of them, they're very kind of laid back. Just depends.
And are they different depending if you're on Shetland or Orkney or Islands or...
I can only really speak for Skye. I don't know about...
There's no legal differences, but probably sort of, you know, cultural differences mean that there'll be differences in terms of the frequency of meetings, I would say.
Okay.
To remember that a lot of grazings are not regulated. You don't have a committee in place at all. So a lot of grazings just, you know, have no committee to govern what goes on them at all.
Okay, thanks. That's helpful. So crofting law is complex, and Section 26 of this bill includes rectifying, or the language used is rectification of the crofting register, and this would allow the keeper to correct inaccuracies with notice and consultation. So I'm interested to, in relation to Section 26, how can the keeper and the Crofting Commission ensure that post-registration changes to whatever it is, boundaries or rectification, again is the language used, how do we ensure that this does not cause legal uncertainty for new owners, lenders or other interested parties, particularly if previously excluded land is later added to a croft?
Can of worms, but I'll go to Chris first and then come back to Brian.
Yes, so I would say in general terms, in relation to both the crofting register and the land register, the balance that you're always trying to strike with the rules on rectification are, you know, allowing straightforward, obvious problems to be corrected without putting the parties whose lives are affected by them to too much trouble in terms of court action, you know, expensive, time-consuming court action or whatever else. But you're always, you know, trying to balance that with ensuring that the system has sufficient degree of certainty that it gives to people who rely on the registered boundaries, and also, I think, about protecting property rights, so that you don't have, you know, an official like the keeper changing boundaries where there's a live active dispute, you know, because disputes of that nature are either for the parties to resolve themselves or the courts. So I do think that the current position in relation to rectification in the crofting register is very tightly drawn indeed. The bill makes some changes to that, particularly around, you know, typographical errors, some new powers to the Commission, some new powers to the keeper. I do think some of that will turn on how they are used in practice, and my expectation would be, particularly in relation to the ones which are on the keeper's initiative, as it were, is that, you know, our expectation is that they would be used sparingly and only when the position is absolutely clear and not disputed by parties, because, as I say, the correct place for them to be resolved is by the parties themselves or the courts. Probably as drafted, I would suggest the bill is reasonably wide in how it allows potential rectifications to come in. I would expect probably that, you know, in consultation with crofters and others, the keeper would issue guidance which would probably seek to narrow that in practice, given the complexities that we know about. So I think you know, I know there are probably other views on the panel, but I think from our point of view, the current law is very tightly drafted. I think making some changes to that are probably sensible. You know, Ailey mentioned earlier the number of crofts with boundary challenges that will need to be addressed. But I do think, you know, where that balance is struck in relation to crofting law is there are probably people who are better placed than the keeper to have a view on that, and ultimately we will implement whatever's in the legislation, of course. So I think there are, you know, sensible changes in there, but some of it will turn on practice around how they're used and where the guidance sits.
And just thinking about what I said about changing or correcting inaccuracies with notice and consultation, and thinking about the register of crofts, the crofting register, the land register, all, how does it all work together? Is there some bits that need to be sorted or proposed to make changes to essentially like make the whole registration process clear and straightforward for everybody, so that we can kind of simplify it a bit?
Well, that's a big question. I don't. People might want to come in on that. I think so. One of the challenges I think that we're dealing with is the legislative regimes underpinning the crofting register and the land register are different, and they're different for a reason, because they're dealing largely with different interests. But you do see occasions where the interests will, cut across one another. We've just spoken about grazing shares and quasi-servitudes, which are, a significant challenge for the land register, in the sense that, we know how to deal with servitudes. Bluntly, we don't know what quasi-servitudes are, and that presents a difficulty in terms of dealing with that. So I think there will be work that we can do in terms of our guidance, but probably one of the most fundamental things is that in relation to the land register, quite often what is required is conveyancing. So the keeper's powers to amend the land register are reasonably limited. Mostly in order to make changes to bring the land register into line with the crofting register, for example, you need to go through conveyancing, so you need deeds to change the underlying position, and then the keeper gives effect to that. We mentioned some of that earlier, so I think from where we are here, it's reasonably difficult to sketch out a completely a regime across both that meshes completely together. But I do think probably as time goes on, there are changes and improvements we can make in terms of how we interact with crofters and lawyers, and the guidance that we give to try and plot a way through that. But I think unless you fundamentally change the legislative structure of the two registers, you're always going to have that challenge.
And the two registers, you mean land register and crofting register? Because
yes,
now we've got register of crofts. Can somebody just clarify for me?
I'm not terribly familiar with. So others
what is it about register of crofts versus crofting register? Why do we have them both?
Ellie, do you want to go, and then I'm going to come back to Brian to answer your initial question. Ellie.
So the Register of Crofts was established in 1955, the same time as the Crofters Commission was established, and the Commission have got a statutory duty to have that publicly available register. And most solicitors think of it akin to the old General Register of Sazines, which is the sort of predecessor to the current land register. So it's old, it's clunky, it's old-fashioned, it's not map-based. That's the Register of Crofts. And since 2010, when the Crofting Reform Act established the land register maintained by the Registers of Scotland, there's been a rolling process of registration every time you hit a trigger. So, for example, if you want to apply to decroft or assign or do anything with your croft, if it changes ownership, for example, you've got to then register your crofts on the Crofting Register, which is map-based. Interestingly, it doesn't contain some of the information that's held on the old register, so that does need to be looked at, I think, if we're not to lose that information. So that is the two registers, and they then exist in addition to the land register. So you've got title boundaries and you've got croft boundaries. My concern about this proposal to increase the Commission's and the Keeper's ability to rectify is that certainly, and I suppose these comments are more directed to the Commission at the moment, but it will provide the Commission to take a view on what the croft boundaries should be. So if they're looking at the Crofting Register, a Commission official, saying, well, that doesn't look right to us, how have they come to that view? And at the moment, the position is that the Commission will not be drawn, and they're quite right to take this approach. They will not be drawn, they cannot be drawn, because it is not within their jurisdiction to have any view on croft boundaries. So the croft boundaries are for the crofter and the landlord, if appropriate, to agree. And it's for the Commission to, go forward and do their regulatory business. It's not for the Commission to take a view on what the boundaries should or shouldn't be. So I'd be a little bit concerned about that. And that's quite a sea change, I think, for the Commission officials to have to cope with, actually, because their training is that you mustn't go there. It's not for you to take a view on croft boundaries. And this sort of does require them to take that view.
Brian?
Written submissions, and I'll just read what I said there. I said that it was potentially opening up a can of worms. And I said that one of the benefits of the existing system is an element of certainty following the 9-month appeal period of what has been registered. Now, this can change. What if, for example, an area of land has been excluded from the croft registration and effectively, therefore, been decrofted? And this often happens. So the crofter submits their plan. There might be areas of land that they've never considered to be part of the croft, maybe outside a fence, might be the verge of a road, but maybe historically that was part of the croft before the fence was put up. So effectively, by doing the registration based on their plan, and obviously their neighbours have the ability to object at that stage, you end up with a defined area that has been registered, that the crofter, the landlord and the neighbours, if they've not objected, are happy with, and you know what those boundaries are, and for all time coming those are going to be the boundaries. If now you have a ability for a material inaccuracy in the register, well, that could be saying, well, there was part of this land that was actually part of the croft, and it should be included. And so that certainty that you have with the crofting register is never going to be a certainty if it's going to be changed. It's probably possibly going to open up a situation where solicitors will be arguing over this in a transaction, but still be saying, what if the keeper or the commission suddenly decide that something that was originally part of the croft is now part of the croft again? The example I gave in my written submissions was that something that, due to the registration process, was maybe originally part of the croft but has effectively been decrofted because it's not been included in the map, is then developed. So somebody spends money developing that. What if somebody then comes along and says, well, that's actually part of the croft and we're putting it back into the croft? So I think this sort of power for the Commission to say this needs to be adjusted, or the keeper to say that, I think it would need to be something where really it could only happen if every single person who was potentially affected agreed, and that was unanimous.
Okay.
Okay.
Thank you. We're going to move on to our final question, and that's from Ariane Burgess. Excuse me.
Thank you, Convener. And we're going to move on to part 2, merger of the Scottish Land Court and the Lands Tribunal for Scotland. And I think I'm going to direct my question initially to Stephen because of your responses in the call for views. So I'd be interested to hear what your views are on part 2 of the bill regarding the merger.
Yeah, thank you. I think our main concern is that this is not seen as a cost-saving measure. If I could say it this way, perhaps, that we hope that this will be used to do more with the same rather than the same with less. We are aware that there have been there will be cases where the experience of, for example, a surveyor member of the Land Tribunal would be useful in something that's a land court matter. There are some cases where the combined jurisdiction would be useful to not have to raise 2 applications, one in each body, but I think that was kind of our main point. We've also highlighted in our written response a few kind of technical points that I can mention if that would be useful.
Okay. Yeah. Thanks.
So it's more to do with the schedule there. Firstly, very small point, paragraph 25 of the schedule the heading refers to certain leases. The text itself appears to refer to all leases. I don't know what the intention there is, but there seems to be a disconnect between the heading and the actual wording. The other thing, from an access to justice perspective, paragraph 30 deals with what are called stated cases, colloquially appeals from the Land Court to the Court of Session. The text there is fairly dense. The Land Court, probably more than any other court in the country, is visited by party litigants. There's two real points from that. One, the rules appear to say that, or could easily be read at first blush, of saying that there's no appeal in agricultural holdings cases. The technical reason why it says that is agricultural holdings appeals are dealt with by the Agricultural Holdings Act, and those are appeals, not stated cases. I'm not sure a party litigant would get that. I had to read it a number of times to realise that's what was being said. The second point is, why do we have two different procedural methods? Why do we appeal a crofting case to the Inner House in a different way from how we appeal an agricultural tenancy case? We are certainly not aware of any reason why those procedures are different.
Okay, thanks very much for that detail. I mean, I guess what I'd like to come back to also is your bigger concern around that it's an underlying cost savings measure. So what would be lost if we created that merger? Because you said that it's useful to go to one for some things and another for another, but if we merged it, what might get lost in that if it is a cost savings effort?
I don't think anything would be lost. Sorry, I meant to say that would be a benefit of the merger, that you could put one application to the combined body. I think one of the rationales behind the merger was a resourcing one. As we've said with the Commission, I don't think there's a lot of fat to be trimmed there. We don't want this to be seen just as a way of saving money and reducing capacity.
Yeah, and reducing resource.
Yes.
Yeah, okay. Anybody else got any thoughts on this merger? No. Oh.
Substantive land court work, as I'm non-practising, so I've got no comment to make.
Okay, thanks. Thank you.
It brings our questions to an end. So thank you very much for your evidence this morning. That has been most helpful. There is, I'm going to go back to the question that Rhoda asked midway through the session. But again, I think she gave you a heads up before we're maybe going to ask at the end, and that is, Ellie, you've touched on the fact that this is maybe just taking the low-hanging fruit on little changes that need to be made, but ultimately it's around the edges, and a bigger piece of legislation needs to come forward. Is there anything specifically in this bill that should be included at this stage, or are we looking forward as this is a step towards greater crofting reform? Brian.
Answered the question. I think there's a particular section that we've not discussed, which I don't know if you're willing to allow me to discuss that, because I think at section 9 of the Act, and I think there's unintended consequences arising from that should maybe be looked at, and it's something that I didn't fully cover in my written evidence, but it's something that again has occurred to me kind of post submitting written evidence, in the same way as there were another section like that. And if the committee are willing to listen to me speaking a little bit about that, I would be happy to do so.
We've got probably 5 minutes left.
That'll be enough. So, section 9 introduces a section 19BA, which is on page 11 of the bill, which states that the Commission may, on an application from an individual who is an owner of a registered croft that is vacant, determine that the applicant is the owner, occupier, crofter of the croft. Now, this is an important provision and something that was seen to be needed because of the fact that at the moment, if you have effectively somebody that's bought part of a croft, doesn't have owner-occupier status, but they may have a big chunk of a croft, and the only way to resolve that is to go through a conveyancing process by putting in a new tenant, and you have to go through an expensive process to effectively make them an owner-occupier. So this was allowing the Commission to get an application that they can just do that. But what has been missed here, I think, is the fact that in most cases where this situation arises, you've got separate owners of the overall croft. So say you've got a croft, but the bulk of it is owned by Mr A, but a small part of it is owned by Mr B. So the crofting register shows them as joint owners, but it doesn't define on the crofting register the division of ownership. That's something that appears on the land register. Here it is saying that an individual who is the owner of a registered croft, they'll only be a part owner of that registered croft, they'll not be the whole owner. So there needs to be a situation here where the legislation shows that they need to apply showing what part of the croft they own and that they're seeking to become owner-occupier of that part. And I think the legislation needs to be reworded to cover that. Otherwise, it's not really going to work in the way that it was envisaged.
Okay. Thank you. That's very helpful. We certainly looked at some of the difference between tenanted crofters and owner-occupier when it came to the test of whether you were fit to be a crofter, and that didn't exist for owner-occupiers, whether it does with tenants. That's something we've certainly looked at as well. So thank you for that. Any other points that... Stephen?
Can I just highlight what's in our written evidence, particularly around aspects of succession on that? Again, Section 16 of the Succession Act is not an easy read, and there's probably some tidying up that could be done there. Whether that can all be done in a crofting bill might be a question, but I'll just highlight what's in the writing.
Thank you. Okay, thank you very much for your contribution this morning. I'm going to ask you to remain seated while we deal with the final agenda item, which we should be able to deal with very quickly. So our next item of business today is consideration of a negative instrument on the Plant Health Export Certification Scotland Amendment Order 2025. Do any members have any comment on the instrument? No? Thank you very much. That concludes our proceedings in public. We now move into private session and I suspend the meeting. Thank you. Thank you very much.